Hello, hello, hello. Good evening, and welcome to Wednesday Night Live from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you guys so much for being here tonight. I always look forward to Wednesdays because it's kind of a more free form opportunity for us to talk about some crazy stuff that's happening in the news. And we always usually try to have a guest. And tonight is no exception. We have a really great guest for you. But before we get started, I wanted to say hello to people who are already in the chat: Kraken Studio, Pammy and Ms. B, and who else? Farm Girl, and a lot of familiar faces, names, I should say. And I'll tell you what, if you're just lurking and you enjoy watching this, just say hi. Say hi. Let us know where you're from, just so that you can check in. Jen St. Peter. It's just makes us all feel good to hear from you all, that you're all enjoying being here with us on a Wednesday evening. All right. Lots of fun. First of all, we have a special guest. It is Joel Waldman from Surviving the Survivor. He is going to come on to talk to us about Donna Adelson, because he is one of the Donna Adelson experts in that realm. They follow that case incredibly closely over on STS. They do really good job of the coverage, and Donna was in court and she testified. So it was some really interesting stuff to get into and talk about with Donna, and I thought nobody would be better to talk to us about that than Joel. And he's got an announcement for us too. They have a brand new YouTube channel called STS Talk, and so we'll talk a little bit about that. It's kind of a joining of a bunch of other channels. It's like every there's a bunch of different shows being run out of the same channel by different experts. I'm probably butchering the explanation of it, so I'll let him explain it to you even better, but it sounds like a really interesting, fascinating concept. They're trying to build awareness about it, so we'll talk a little bit about that. As always, on Wednesdays, we do a poll because there's a lot going on. I don't know how much time we're going to have, if we're going to be able to get to everything, but I would rather know what you guys want to hear than tell you what I'm interested in talking about, quite frankly. So here's what's going to go on the poll. First, we have Jeffrey Ferguson. This is the Orange County judge who shot and killed his wife after a night out. I don't even want to say drinking, just maybe casually drinking. A couple of margaritas at dinner. They started bickering. The argument continued to follow them on the way home. There was some sort of discussion about, whether or not he had a gun. Why don't you point a gun? It's a crazy case because the guy was prior a prosecutor. There he is, older gentleman, then sat on the bench in Orange County for forever, pulled a gun out of his ankle holster and shot and killed his wife. And he testified earlier this week, and they are currently deliberating on that case. It's 5:00 on the West Coast right now, so I don't think that they had a verdict, but I'm going to ask Kaylin to check the news really quick to see if they did, because it was a case that went by very quickly. So we can talk about that. The other one is Timothy Hausholtz. This case is interesting to me, not so much for the facts of the case. It's a case involving the abuse of a young child, and the child ended up dying. And the way that he died was really awful. He was abused and made to carry around, a 7-year-old kid made to carry around a heavy log out in the snow, and he ended up dying. Horrible, horrible, horrible. But the prosecution and defense came to a plea agreement, and the judge rejected it on the eve of trial and said, no way. That's the judge. Said, try again. I don't like this. And I've got some pretty strong thoughts on that one, on what I feel about judges getting involved in plea negotiations and if it's a good idea or not. So that's case number 2. And then case number 3 is Rex Heuermann. He is the Gilgo Beach serial killer. That is Rex right there. He was back in court. They were talking about DNA. They were talking about whether or not to sever the trial. They were talking about whether or not for a change of venue. But his attorney made some interesting comments in a press conference afterwards about whether or not DNA was found in the quote unquote kill room of his basement and what that means about the strength of the case. And I've got some strong feelings about that one too. Jay says, Rex Heuermann, my neighbor. Hey, Jay, good to see you, my friend. It's been too long. I'm glad to see you. But I'm going to have to do some follow-up questioning about your neighbor. So those are the 3 for the poll. We'll put that poll up now. We'll get our results in a minute, but what we're going to talk about while we're waiting for Joel to come on is, of course, Karen Read. Karen Read, the case that never ends. Karen Read, the case that keeps on coming back for more. Karen Read, the case that has more twists and turns than any case I have seen in recent memory. And it's just fascinating to me. So we will get into what happened in court earlier this week and some thoughts on how I think we really should be viewing it. Rowena Rain says, Gisela and you are truly the best. Oh, if you're putting me in a group with Gisela, I am really touched by that. So thank you so much, Rowena. She's fantastic. And we're going to try to have her back on Wednesday Night Live again soon. Problem is that when we put this on at 5 p.m. on the West Coast, it's like 2 a.m. Where she lives. And she's done it before, and I didn't realize how much I was putting her out, but she finally said, I just can't do it anymore. So we might do like a recorded interview with her. Redondo Beach says, were they at the Quiet Woman? I don't know. I usually I'm not lost. I'm a little lost, my friend. I'm so sorry. Were they at the Quiet Woman? I don't know. But yes, no, I don't know. All right. Karen Read. Let's jump into this one. Before we do, we got to give our sacrifice to the algorithm gods. Like this if you haven't already. Subscribe if you haven't already. And let's get going talking about Karen Read. All right. First of all, Karen Read, there she is. This case, for some reason, I feel like sometimes I avoid talking about it because it has become so volatile, such a charged case to talk about. People have become so embroiled and they have their sides on this thing. And it's hard sometimes, I feel like, to talk about it objectively and just kind of look at what took place in court. But luckily for us today, we're not talking about the guilt or innocence of Karen Read at all. We're talking about something really procedural. We're talking about discovery and disclosures of different things, and what kind of communications are you allowed to have with experts, and what kind of trouble can that run you into. And it's interesting, and it's one of these things that you do not see come up all that much because there are some unique particularities to this case and why this is coming up now. And the first thing I will say about this is, when we're talking about this particular issue, I think it's important, and I told Kaylin that we weren't going to have any video tonight, and I absolutely lied to her. We are going to have some video tonight, and I'm going to get that set up myself because the audience in this particular case or this particular motion is Judge Cannoni, okay? She's the one going to be deciding this. And what do I mean by that? Well, this isn't an issue before the jury. We as bystanders in the media don't really matter. This is an issue for the judge. And so I think it's important to hear what the judge's concerns are with this whole thing. Why is she calling this hearing? We all saw the way that the last week, the hearing was cut short and the judge came back out after 20 minutes and she was visibly shaken. She was shaking and visibly shaken, and her voice was quivering because she was so upset by something that she felt that she had learned. So I think it's important to remember they're all arguing to an audience of one here, even though it seems like they're putting on a lot of presentation and they know cameras are in the courtroom. The only person they should really be concerned with is Judge Cannoni here. And let me get this queued up. And I feel so silly because I was just talking to Kaylin before we started about how much preparation we put into all of this stuff. And I was patting ourselves on the back. And then I forgot about the one thing I wanted to get into, which was this this bit from Judge Cannoni. I want to play you her remarks that she makes to everyone before they started their arguments on Tuesday. And when you're watching this, I'm only going to play a few minutes. She doesn't take very long to do it. Think about She is outlining, she's handing to the attorneys what it is that she's concerned with, and therefore how their arguments should then respond to that, and why I feel like they may have missed the mark in some senses, and in other places I think they may have hit the mark right on the head. All right. Let's see if I managed to do this on the fly and didn't mess everything up. Okay. All right. Here we go. Tell me if you guys can hear this. Okay.
So last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ACA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ACA witnesses testified. There is another email that was 2 days before the trial and 2 days or after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ACA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails.
Okay, and I know it's a little bit soft, so if I come in loud, I apologize, you guys. But let's just dissect what she's first saying there in coded language that only a judge could say. She says, first of all, we're talking about questions of candor. That means I feel like I may have been lied to. I mean, that's really what she's saying. She's saying, I feel like either I've been lied to or I've been misled, or you guys have purposely left out some very, very important stuff. Then she says, this is important, so I wanted you to prepare in whichever way you needed to, meaning if you needed to lawyer up, I encourage you to go ahead and do that. And this could have profound effects on the trial and the fairness to Ms. Reed. What does she mean by that? What does she mean, the fairness to Ms. Reed? What she means is, if I kick off one of your attorneys. I mean, I think that's how dead serious she is setting the table right now. I may kick off an attorney, and that might have profound effects on the fairness to Ms. Reed. Okay, so she's in the most judgerly of way, really laying down some serious stuff here before they begin this hearing.
So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is, what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me.
I just love how she puts it. So that was concerning to me. So she's isolated, I think, the real issue here. And I'm getting word that Joel might be joining us soon. So we might have to finish more of this conversation later. But she's isolated it. She says, listen, I went back and I looked at the hearing that we have where David Yannetti got up and said that we gave everything to, we haven't had any conversations with ARCA. She took a look at that. She took a look at the voir dire where there was questioning of the ARCA people. She took a look, this was interesting to me, to their testimony. She's curious, was there representations made during their testimony that may have been problematic? And then she took a look at closing arguments. In other words, she's looked at every space that the defense has opened their mouth regarding ARCA, okay? But what she focuses in on, what she's most concerned by, according to her own words, is that February 6th sidebar, the sidebar we just had. The February 6th sidebar, and she just now pulled the transcript, had the sidebar transcribed, like the sidebar is being recorded, but she had it put into a transcript, and she just read back Alan Jackson's own words to him, where he says, we've got nothing, they have everything we have, we didn't hire them, we didn't pay them, we didn't talk to them, they've got everything, it's all, we've got nothing more to do here as far as our obligations go. And she concludes that with saying, that is very concerning to me. To me, she wanted this whole hearing to be about that moment right there. And what are the problems with that moment right there? And I'll explain to you why I think that is the only moment in which she can really have any concerns. Okay. But this is just the rest of her comments here.
And do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed, sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Okay. And then they start into it, and Alessi begins his arguments. And I'll say right from the start, I thought Alessi did a fantastic job. I mean, the guy's a brilliant lawyer. He laid out everything. He took a very long time to explain all of it, which first of all, you got to kind of think to yourself, the defense knows they might be in a little bit of hot water here if they took that long to argue everything. Usually when you feel like it's not a big deal, you're not taking 6-something hours to explain your entire position on the entire thing. But he's a remarkable lawyer. I thought he did a fantastic job. But to me, Debbie agrees. I think Alessi was awesome. I think he did a really good job of going back and explaining everything. Here's just some broad stroke thoughts about these arguments, okay? First of all, it's interesting to me that Alessi did argue this because they didn't bring in other counsel. They just brought in Alessi. But Alessi spoke, in my view, as if he were counsel just representing the defense team, Jackson and Yannetti, for that purpose. In other words, he was arguing as if he hasn't had conversations with Jackson and Alessi. He was making an assumptions as to what they may have been thinking at different times when they made certain representations to the court. Well, they're right there, right? I mean, if we really want to know what they intended by those representations and what was going through their head, they could stand up and say it, I suppose, or he could say, I've spoken to them and this is what they meant, I suppose. But it seemed a lot of it seemed to be as if he were representing a client and making arguments about what the court can assume based upon what knowledge they may have had or didn't have at the time that they were making those representations. Debbie says, but don't you think Alessi went into such detail to get everything in the record? 100%. I also think Alessi knows what we all know in that that last comment that the judge said, the third reason I paused was because I needed time to reflect because I'm going to have to make certain findings and make some very difficult decisions. That's ominous. Like they all knew going into today, she's not happy and they better really explain this to her and calm her down, or they're going to be having some major problems with how this case proceeds from here on out. Okay. I don't want to belabor the entire history of this whole thing, but I think it is important to at least talk about the timeline about how things took place. Hey, there's Bob. Hey, how you doing, my friend? Good to see you. Now I'm nervous. I got Bob and Jay watching me. Okay. This goes all the way back to February of 2024. February of 2024, ARCA produces their report. ARCA was retained by the federal government to do some accident reconstruction. That's what they do. That's what they're experts in. And they create a report. They were not hired by the defense. They were not hired by the Commonwealth. And there were no allegations of any kind of communications before their report comes out. That is, to me, a fact in stone. And that's a very helpful fact to the defense because what they're trying to do is say that these witnesses are independent. They operate independently and that they, we got the whole crew here. Hey, Melanie, that they are independent. They operated independently. They came to their conclusions independently. And therefore, we are allowed to point that out to the jury. Okay. That is something I don't think the Commonwealth can change at all. And nobody's even contesting that. Here's where the problems start to arise. In March 20th, Alan sends an email to ARCA asking for their engagement letter. Let me say this first of all. Alan is from Los Angeles. I've known Alan for over 2 decades. He is a incredible attorney, and I think he is a very honest attorney. Honest to the point of paranoia sometimes. He would never want to risk his bar card for something. Wow. Court TV too. I like it. Would not want to risk his bar card for something. Okay. But he tells ARCA, send me your engagement letter. In California, and I think this is important to say, there is nothing wrong with this. In California, you can speak to an expert as a defense attorney, retain an expert, have them do testing for you, have them produce a report for you, and not disclose any of that to the defense. It's only until the point where you anticipate calling them at trial does that become discoverable. California has reciprocal discovery laws, but for the defense, it doesn't kick in until you feel that you're going to call that witness, because California allows the defense to strategize. And if they talk to an expert and the expert doesn't say something that's all that favorable, they don't have to turn that over to the prosecution, and they can decide we're not going to use it. I think it's important to understand that, because it's important to understand what I believe may have been partially going through Alan's mind when he's saying, send me a retention letter. Okay. Send me an engagement letter. We're good. You're good experts for us. We want to have you testify. Let's get this whole business side of things wrapped up. Okay. Alessi makes a point of saying that, that Yannetti was not CC'd on this. I am not as thrilled by that point. You're part of the defense team. I don't care if you're CC'd or not. I feel like everybody on the defense team who's engaged by the same client is expected to have the same knowledge, okay? But he makes that distinction. Fine. March 22nd, they get the pause email, which has been referred to now, where ARCA spoke to the feds. The feds said, hold off on doing anything. And everything stopped. And I think at that point, had it just been that, there would be zero issues here, quite frankly. I don't think any of what we have just heard to that point is all that problematic. Then we get to June 10th. We have a hearing on the ARCA experts and whether or not they're going to testify. And this is where the judge says, are you going to call experts that you've never spoken with? This is not her verbatim, but that's essentially what she's saying. She's kind of shocked by that. You expect me to believe you're calling witnesses you've never spoken with. And Yannetti says, we've only spoken to ARCA about coordination. Here's where that becomes concerning to the judge, because now it looks like maybe there were conversations that were more than coordination. We don't know, but at least there seems to be some suspicion of that. And now that we've gotten all heated up and in the midst of it, Joel comes in and ruins everything with his absolutely impeccable timing as always. But he's got a lot of going on. The guy's going, I think he's done about 12 different podcasts today. So I'm not going to continue to have him sit there. We're going to have Joel jump in really quick. We're going to talk about Donna Adelson, switch gears dramatically, but I promise you we will get back to this because I think there is some interesting things to be had about all of this. All right. With that wonderful introduction, please everybody welcome Joel Waldman from Surviving the Survivor. How are you doing, my friend?
Doing very well. Love being here. Thank you for having me back. And I will reserve all comment on Karen Reed other than to say you're not going to find it on Surviving the Survivor. I can guarantee you that. We'll do other stuff. I've had it up to my eyeballs with Karen Reed, and it is Josh, you will get hate mail should I not say it? I won't say it.
I do feel like I'm walking on incredibly thin ice when you start talking about that case, because people know it very well. They follow it very closely, and people have got some very strong feelings about it. And I hope so far no one's been sharpening their pitchforks when I've been talking about it. But thank you for saving me, first of all. Jay says smart of you to avoid it.
But let me just say I will not be covering it on my channel. I've had enough.
Well, but what you are covering is a case with almost unanimous kind of feelings of let's go ahead and get this woman. And they want we want to talk about Donna, says Michelle. I want to talk about Donna too, because she was in court this week, or actually yesterday, to talk about I call it the jail is tough motion and the no phone call motions, right?
Yeah.
Before we jump into that, though, Joel, really quick, because what time do I have to let you go?
I'm good, man. I'm all good. I was supposed to do Court TV. I'm not doing it. Although this is a record for me today. I want to brag. This is like the 6th thing I've done today. I try not to do that. I am very humbled and I love doing it. But I can't really think anymore. I had a couple of like prior obligations that I forgot about.
So this is the 6th of 6 things you've done. So you're completely fried by the time we're talking to you.
But I feel good, man. You're gonna get the loopy Joel, and I can go. I can go for a while.
Good. All right. Before we jump into it, though, I still want to talk about this before I forget. Is that you have a brand new channel called STS Talk? Could you tell us a little bit about what that is?
Well, thank you for asking. I didn't even ask him to ask, to be honest.
I know.
But yeah, it's an idea that I had. We have obviously Surviving the Survivor, and we've been at it for 2 years. But we truly do have. Thank you so much for putting that up there. Mainly because I don't know the exact official name, but you'll see there. Where's the handle on here? It is. It's True Crime Talk is the handle. No, STS Talk.
STS Talk.
I knew I would screw that up. So, long story short, we really do credit to Steve Cohen. We have amazing guests. We do a panel every single night, which is not easy to do. Credit to Steve Cohen, the COE, Space Coast, the mods. And so we had a lot of best guests coming up to us saying, hey, I've always wanted to have a show. Hey, I specialize in X, Y, or Z. And it made perfect sense. So basically, it's kind of like a collective. I look at that. Steve Cohen has the expression rising tide. Thank you, Jody. Rising tide lifts all ships. And so everyone's in the same boat. Everyone's trying to learn this new world of, alternative media. And I had this idea to take all this knowledge and give them, their own shows. So it's very kind of fast and loose in that we don't have a real system in place, and we're rolling out shows slowly. But just to give you a quick example, the Geo Profiler, he's a best guest. He does geographic modeling and all sorts of things to help find missing people and solve cases. So he's doing a show as it pertains to that. We've got Detective Troy Looney, who I think is the only PhD detective that I know of. So he goes by Dr. Detective, and he's going to be doing a series on detective work and how detectives investigate, and on it goes. And as we go, we have the Gold Shield show coming up, which is a really well-known, good podcast by 2 former NYPD detectives, including Tom Smith. Thank you, Reborica. It is cool. Joel just up. Thank you so much. And so that's the idea. And it's everyone's got a shot. And for full disclosure, I did invite the man right here who's looking very Anderson Cooper-like with his beautiful blue eyes. But I did invite Ritter, but Ritter is attorneying and doing this. But maybe one day we'll get Josh and we'll collaborate with him too. Rob D'Amico
shows me to stop attorneying. It'll free up a lot of my time.
Yeah, there you go. So it's funny. Maybe this is a secret. I don't know. But a lot of attorneys say to me, hey, I'd rather be podcasting than attorneying. So we've got a lot of those too, and a lot of people who are doing it. But that is the idea. Please come support, come watch. And I think you'll be impressed with the new shows on the new channel.
Awesome. It's a fantastic concept, and I hope that it thrives. So I'm glad that you were able to share that with us. Let's talk Donna, though. Mm-hmm. She's in court because she wanted two big things, and then she testified. But catch us up, but just to set the table, she had a motion to suppress because she made a phone call with Charlie while Charlie was in custody after his conviction, correct? And she's still speaking to him because she's out before she's been arrested. And part of the motion had to do with they're trying to suppress that because they're saying she didn't realize she was still being recorded at the time that the recording is still going, and she starts to make some pretty damning statements about killing herself or fleeing the country. And then the other part of the motion was jail sucks and she's can't sleep. She's got health conditions. She's got here. I wrote a lot of them down. She's got pain, a bad mattress. She needs a Band-Aid and Neosporin for a boo-boo. She's got wax in her ears, and jail has a high-carb diet. And for those reasons, she would like to be let out of jail. Donna needs some Q-tips. Yes, she does. But tell us, how did this play out? How was it received by the judge? But more importantly, I think people just want to know how Donna actually testified. How did that go?
It was a disaster, in a word. It's interesting. I mean, you would know about this a lot better than I would. First of all, I was just having trouble. It's not sour grapes, but I don't get the 10,000 comments that say Josh is way hotter than Anderson. Josh is gorgeous. I don't know how Ms. Ritter feels about it. Luckily, I don't get those comments, so I don't have to be in the same position that Josh is. I'm not upset. I'm not getting older. My ego is not damaged at all. I'm perfectly fine. I'm perfectly fine. But back to Donna. It's not about me. Karma would be yelling at me. So, you outlined it amazingly well. There are two motions that were kind of put into play by the defense, and it's one motion essentially says jail is tough, and like you just outlined, I was bleeding and I didn't have proper bandages. And close your ears if you're squeamish, but you had blood coming from her arm or her elbow, and there was not a Band-Aid, so she had to borrow a female sanitary napkin, and she was beside herself, and the list went on. I mean, the one that everyone's sort of poking fun at the most is one, I mean, you see, and again, I'm not body shaming here, but she does have large ears. I mean, we can all agree on that. However, her ear canals are alleged to be incredibly small, and therefore, when there is wax buildup, it is incredibly painful. So, Josh Ritter, in your entire career, have you ever heard a defendant use the ear canal excuse to want to get out of jail? Have you ever heard that, Josh Ritter?
No, absolutely not. And I have some feelings on the reason why they brought this motion. That's all. If I am her attorneys, and I am sure that they cannot get any work done when they go visit her. Mm-hmm. That they try to interview her about listen, we got to go over these transcripts. We've got to talk about this evidence. We've got to do, how are we going to strategize this and that? And I guarantee you, for the 90% of those visits or calls or whatever they're speaking to her, she's talking about her wax in her ears and the high carb diet and the bad mattress, and they just can't get past it, and she can't get past it. And I think this entire motion was brought so that she could do this. They said, fine, here's what we're going to do. We're going to file a motion. We're going to tell the judge all the horrible, horrible conditions you're suffering. We're going to ask the judge to let you out. And in fact, Donna, we'll do you one better. We'll let you tell the judge all the horrible stuff that you've been going through. And here's your moment. And I think that's honestly where this came from. The motion regarding the phone calls is a little more interesting to me, but this thing regarding getting her out, I don't think anybody feels it has a better than a snowball's chance in hell. And it was just an opportunity for her to get that said, so that hopefully when they go talk to her again, they can say, Donna, we've already talked about this. The judge said no.
That is a fascinating perspective. I did not think of it that way, but that's why I said you'd have better insight than me. And it just goes to show why we've got to get Josh out of lawyering, because you got to listen to people like Donna Adelson complaining that her ear canals hurt. But Stephen Webster, who's a guest on my show, and Dan Markel's post-divorce attorney. And the other sad thing is we hardly hear Dan Markel's name, and he's the victim. So I think we have to remember that. Yeah. But Steve Webster had the line of the night. He calls them eerie canals because they're on Donna Adelson. So I like that line. But that's a great point. I mean, maybe they had no other recourse. So Donna in the hearing today said that, corrections officers are yelling, "What are you, deaf, Adelson?" That inmates, that she's not hearing inmates. And that could play right into what you were just saying. I mean, maybe it is a real issue, being hard of hearing, and they did make the lawyers made the argument in court today that they're not able to get the work done, that she's quote unquote not going to have a fair trial. Now, I thought that was just lawyering and posturing by the part of the defense, but maybe there is an element of truth, and maybe she is such a pain in the you know what that the lawyers are like, all right, screw it, we have no other recourse. We're going to do this. We're going to file this motion just so we can basically shut her up. There's no way this motion is going to fly. Judge Everett, who's a really great judge, basically said, look, I'm going to reserve ruling. I just asked Stephen Webster, who's an attorney in Tallahassee on my show. Guy's awesome. He has such a command of the courtroom, and I just love the way he speaks.
He's great. His demeanor is fantastic.
Yeah, Karen Reed, who I won't mention again, Karen Reed. They could use Judge Everett in that courtroom. He would be running it a tighter ship. But so, I mean, the argument today was really jail sucks and I want to be let out. I mean, that's really what it comes down to. I just had an inmate on who was like, there's not a single thing here that stands out to me. It is literally just a form of whining. And look, she's accused of a murder for hire. And most people, 98% of the people I come across, if not more, think she's guilty. And jail's not fun. But I mean, Josh, let me ask you a question, Josh. I mean, you are presumed innocent, if I'm being attorney-like, until proven guilty in a court of law. Are these jails, I mean, do they need to be, and I'm going to get hate for this, but do we need to take a closer look at incarceration, particularly in county jails in this country? Like, are these inmates really being treated as badly as she says they are?
I mean, there are some jails that are under kind of federal oversight and scrutiny. I think the jail out of Atlanta was having a bunch of problems that they had to recently go in there and kind of take a look at it. I know that here in Los Angeles, Men's Central Jail had, they had to go through a bunch of reforms and things like that. So, I mean, yeah, some of these jails are awful. Yes, people are presumed innocent, but you're talking about apples and oranges, right? I mean, it's like jail being bad is one thing, but whether or not that means you get out when you are, regardless of presumed innocent, when you've already demonstrated that you're willing to flee the country and you're now good for orchestrating, or perhaps good for orchestrating the murder of a man, you're going to be kept somewhere. I think the Sarah, is it Sarah Dugan, the Florida prosecutor?
Yeah.
My favorite statement that she made wrapping it all up was, she's in jail, it's not the Four Seasons. And I think that, that's absolutely right. Listen, does she have some legitimate complaints about perhaps being the subject of extortion from other inmates? Yeah, I think that she might be kind of singled out, given her age, given that, word gets around these jails that she probably has money, word gets around that she's kind of a celebrity. So they're probably going to focus on her, and they probably need to do a better job of protecting her, maybe putting her into some sort of, different confinement. But she's not going to get feather beds and spa treatments. I mean, it's just it's going to be an awful experience. And she, quite frankly, better get used to it, because after this, it's prison, and probably for a very long time. Again,
I just want to, I want to be, because I am taking a bit of heat in the chat, which I'm used to, but in no way do I think she should be out. And jail is rough. Do not confuse the question I posed to Josh with thinking that Donna deserves to be out. I mean, there is also a huge irony in the fact that she is basically begging to be released into Tallahassee. That's where she would live if she was granted this motion. And the whole plot, the whole murder for hire plot, was devised because Donna hated Tallahassee so much that she wanted her kids anywhere but Tallahassee. Right. Now they're literally proposing that she is confined in Tallahassee, literally confined with an ankle monitor. I mean, so there's no irony lost there. I mean, it is crazy. And I got to say, I've been to Tallahassee a bunch of times for this case, and it is a very intelligent community. It's rated the smartest community or city in Florida because it's the capital, a lot of bright people, a lot of graduates of graduate schools, et cetera, et cetera. What we saw today in court, the jurors are going to look right through it. I mean,
Yeah.
I said this on my show, like Charlie was convicted and he was very smooth on the stand. He was almost too smooth. But Donna, I mean, her acting, the way she presented herself on the witness stand today, providing testimony, she's in a lot of trouble. I mean, she's in a lot of trouble if she acts.
And I think she also has demonstrated that kind of disconnect between how average, normal people think and how what she's saying will be perceived by them, right? Like, I think the same happened with Charlie. He was so confident in what he was saying would be believed that there's almost this kind of dissonance where he cannot comprehend someone not believing something he's saying. And I feel like if she were to testify, would probably be received the same way by the jurors. If this is any indication of it, that she thought, I think she honestly felt telling the judge about these grievances, the judge would be nearly beside himself, clutching his own pearls and trying to get her out of jail because he couldn't imagine the nightmare that she has to live with. And the judge is like, I mean, the judge wasn't going to do it, but I do believe the judge felt like, please, this is a waste of my time, but I'm glad that we got that behind us so that no one can say I didn't, give her every opportunity to be heard.
Yeah. I got more beef with you. How come you got shaming at Jay to fit? These guys never come into my chat. I'm getting very insecure.
Here.
Ritter,
the whole gang's here.
My insecurities are overflowing.
They're all here because of you, though, Joel. They heard that you were coming on, and they said, "Okay, let's hop over there real quick."
By the way, Annalie Finch is my friend, and she's in the chat. So shout out to Annalie. She's always in our. There you go. She's always.
Oh, thank you, Annalie. That's very sweet of you too.
Yeah,
Appreciate
she's very
that.
generous. So it was really amazing. I mean, Josh, you would know the answer to this too. But one of the things that one of the best guests on our show said is that they likely put Donna up on the stand today to sort of beta test her to see how she would perform. And is that a legal strategy? Like, would 100% you do that? Oh yeah,
I think
she failed miserably.
I think it's absolutely a beta test is a great way of putting it. And it's under the best of circumstances because it was such a specific issues that she's testifying to that they don't have to worry about her saying something that will come back to bite them later on. Because, there's nothing that she said, if they do decide to put her on the stand to talk about the crimes, nothing that she said will come back to haunt her. Because she's not really going into the facts and circumstances of the crime. So it was a great way to hear her and see how she would perform under cross-examination without really putting them at risk. But I agree with you. I think they saw this and they thought there's no way. And maybe also a way to convince her too. She might be back there telling him, I want to testify. And after yesterday, they can say, do you see how that went? That did not go well. You see how bad cross-examination can be. You're not going to fool these people. And maybe that will convince her not to testify. I don't know. But the meatier part of this whole thing I wanted to talk to you about was the phone calls, right? So they had this because when I first heard that they were trying to challenge the phone calls, I thought it's absolutely got nothing to it, because if you guys have ever heard these phone calls, you cannot speak for more than 30 seconds without a recording telling you this is a recorded line. You are speaking to somebody who's in custody. Everything you're saying will be recorded. And it absolutely is. And I always love when people, first of all, I've had many cases where I've used these jail phone calls. And first of all, the first thing they'll try is to whisper that somehow we can't pick up the whisper, or they try to speak in code, or you can tell they just flat out somehow don't believe it's actually being recorded. But all of this stuff is being recorded, and it's really, really good evidence many times for the prosecution. But what made this slightly different was, and I'll let you explain this more, they're saying that these calls would drop off frequently, and that when she's making some of these statements, that she felt like the call may have been dropped, and therefore their argument is that then her expectation of privacy somehow kicks back in. That if she feels like the call is ended, now she's just at home on a dead phone line, and that's where she has an expectation of privacy. Tell us how that all played out.
Yeah. So again, there were two motions. One, basically, jail is tough, and I have the small ear canals, and I need to get out because it's not safe, it's dangerous, and all these other things. The second one is what you're talking about. It's the so-called, we call it the hot mic call. It's a specific call that she made in the week after, and it's kind of funny because the defense attorney got the date completely wrong today, but it was in the week right after Charlie was convicted. He was convicted November 6th of 2023, and I think this call is made on November 7th, the next day. And in that week period, Donna was arrested exactly 1 week after Charlie's conviction because they got word again that she was trying to flee to Vietnam. So, basically the argument is I was talking to my son and he, unbeknownst to me, hangs up. Now, she had a friend there that she claims was an attorney, which was just, I believe, a friend, but she was making the argument about attorney-client privilege. It was her name is Susan Brotman, and her husband was there, and Harvey were there. So Donna, as my mom would do, there's been times where my mom has literally been on a FaceTime call or something with me, and she keeps her phone around her neck, and she'll on a strap, and she'll just let it dangle. And it's like we're going on with our lives, and 30 minutes later, I hear my mother's voice, and I'm having every time I hear my mom's voice, my heart rate raises. But it's kind of I don't want to throw Carmel under the bus, an old people problem. So Donna had no clue that that Charlie had hung up. Maybe he was tired of his mom. So he hangs up and Donna keeps talking. But to your point, there is that recording that loops over and over and over. So they're making the argument, the defense team, that because Charlie hung up, there should be an expectation of privacy. There really isn't. And I think they're going to lose this as well. But the real reason behind it, this is the call where she talks about possibly self-unaliving herself, and also this trip to Vietnam, that she wants to get away to Vietnam. One of the things that I will just never understand, Josh, and I say this repeatedly, is a family with this much wealth and means that they chinced on a one-way ticket instead of, not that a two-way would be any better, but at least there would be some credibility there. Like Charlie used to spend time in Vietnam, and they had been to Vietnam. So she could have just said, "I love Vietnam. We were planning to come back," but she buys a one-way ticket.
That's a really good point.
Yeah. So
I had never thought of that why not just buy the two-way ticket in case there's trouble? But it's like the one-way ticket is such a more convincing point that they never intended of coming back, right?
100%. Now it's like this consciousness,
the extra few $100.
Yeah, it's crazy. I mean, and that might be the one thing that actually really brings. I mean, there are other things, but I think that's a very small but huge thing that could bring her down. The other thing that's really interesting on that call, Josh, and I'd love your perspective on this, is that she invokes Dan, she uses Dan's name, and Dan Rashbaum was her defense attorney. So everyone is presuming that's who she's talking about. But it's a very fine line, because at that point, Dan Rashbaum is not Donna Adelson's attorney. He was her attorney previously. I think she was in the process of hiring him, but she's basically saying Dan's giving me advice, in so many words, to flee the country. And then today in court, she's now mentioning Dan multiple times. I counted at least 3 or 4 times. And I'm wondering, is she inadvertently or intentionally now throwing Rashbaum? Yeah, you see Brittany saying she did admit it was Rashbaum today. So is she intentionally or unintentionally now also bringing Dan Rashbaum down, who I've talked to other lawyers, was towing a very fine legal line by kind of giving this advice to get out of Dodge.
Well, a few things to unwind from that. First of all, it's bad news for Rashbaum on top of all the other bad news if he was actually advising her to leave. If he's I mean, you can advise your client of many different things, but you cannot advise them of how to break the law. And if you're advising them of how to be a fugitive from justice, that's a bad thing. I've had clients ask me many times, what would happen if I would go somewhere and they can't find me? And I say, I don't even want to get into that conversation with you. We cannot talk about this. I am advising you that is illegal to do. You can advise clients of, if they ask you, where do they have extradition laws? Well, then that's, I guess for some attorneys, a very fine line or very fine hair to split and say, well, yeah, I can certainly inform you as to the laws in different countries. But I think this is, again, why it was a huge mistake for him ever to try to have been representing her in this trial after all of the kind of murkiness with him representing Charlie, and then how much of that was he representing her at the same time. So it's I think the judge today, probably hearing all of that came up, he realized how much better it was of a decision to have them all kicked off and get a clean trial going, so that this, you imagine if Rashbaum was still her attorney as this is all happening, it would have just been absolute chaos. And then I think I forgot the other part of your question, but go ahead.
I think that was the main part of the question.
Yeah.
I mean, you see Lee T here, right? They're saying that Donna went a lot further and sort of, I don't want to say incriminating, but throwing Rashbaum under the bus. I mean, he had to be watched.
What
he had to be watched.
That was your question. What strategy could that be? Yeah.
I mean, just so everyone knows, there was a formal complaint filed against Dan Rashbaum for the way things went in this case. So I think he's definitely being scrutinized. I don't know where that stands, but I know Josh well enough to know that he's not going to be doing stuff that's borderline unkosher. But I personally like Dan. I've met him. I've talked to him. I don't know what his ulterior motives are, if there are any. He does have not in any sexual way whatsoever, but he has this unusual attraction to Donna, almost like a maternal figure. He talks about that. And so I think he was towing, defense diary saying conflict, but he was towing a very fine line. And today, and I think he backed away from it, but then Donna was trying to I don't know, maybe bring him down. Maybe she's upset about the conviction. I have no idea.
I don't see how that really plays to her advantage at trial, though, at all. I mean, maybe there's some outlier issue I'm not spotting right now on appeal that she could say that, based on his advice, she was making very stupid decisions at the time, which includes the decision to leave the country that is now being interpreted by the government as if it was a consciousnness of guilt, but instead it was just based upon my own attorney's advice of how to get some time away and clear my head. I don't know, but I will tell you, I don't think it's going to play for a jury if it even gets in front of the jury. So I don't. Maybe.
By the way, in fairness to Donna, which it's tough to do, but she did say, and this is true from Nan, that Dan said, look, at that point she was not under arrest. I think she knew she was being watched. I think she knew that she was being looked at very closely. I mean, I think Wendy Adelson is in the same boat right now. I just spoke to Stephen Webster again, who was once Dan Markel's divorce attorney. And he said he has no doubt that they're going after Wendy, but Wendy has now gone to Austin, Texas. But it is true that at that point, she was not arrested. She was not under arrest. And so maybe Dan was just innocently looking out for her. I don't know.
Yeah. Yeah. Well, the way it ended, help us understand, the judge did not make any decisions, right? He just kind of heard arguments, took it under advisement. Do we have a date of when we expect to hear about these things? And do we know when their next court date is, or what's the latest in developments on that case?
Yeah, on both motions, Judge Stephen Everett said he was going to reserve ruling. I mean, overwhelmingly, everyone I talked to said he's going to deny both these motions, that they're not going to fly. In terms of a timetable, Webster said a week, 2 weeks. I think it's going to come back much quicker. You know, I asked this question to Webster, and I'll ask you, since it's not my show, and I'll ask a question, is what goes on in the judges' chambers? Like, lawyers have a whole team to confer with, and I know there's a chief judge, but this seems to me like he has the answer. Like he knows the ruling. Like, so
Yeah.
what's the inside baseball? Does a judge go to the chief judge? Webster said that being a judge is a very lonely existence. Do they have to give the appearance that the court is really weighing this issue? And if I give you this ruling tomorrow, I haven't really weighed it as much as I should have. What's happening behind the scenes?
No. In fact, I'm used to most judges just making the ruling right then and there because they've had the moving papers. The bulk of everything they need to make their decision on is based in those moving papers, and the oral arguments in court are usually just the attorneys kind of posturing a little bit. It's rare that something will be brought up through the arguments of attorneys that will really change a judge's mind if they've thoroughly been briefed on it already. This is a little different in that he heard testimony, so maybe he wants to kind of digest some of that testimony. But I see a lot of judges that do these kind of take it under advisement thing. I think that's just to perhaps sometimes avoid the heat. You know, they don't want this kind of ongoing back and forth argument with attorneys. And they're like, okay, I've heard everything and you'll get my answer in the mail where I don't have to face you when I make it. I don't think that that's what he's doing here. I think he may need a opportunity to kind of digest what he heard about her testimony, though I don't think that changed anything. But to answer your question, it is a lonely job. I have some friends who are judges, and they hang out with other judges, but for the most part, they're making these decisions on their own. Now, they have law clerks, they have research attorneys, they've got people who are looking stuff up for them, and the better judges also call the more experienced judges and will run stuff by them. But, it's kind of viewed as like, listen, you are a judge and you're running your own ship here, and you better kind of know what you're doing. And many judges just don't speak to anybody about the decisions they're making. If they're having lunch with the other judges, they're talking about, their golf game rather than what decision they're making in court.
That's interesting. I'm always curious how it works, on the inside. One other thing that I think is really like intriguing. If you remember when Donna was arrested, they had some phones, cell phones, and iPad, and they seized all that. They took it. And there's kind of word floating around Tallahassee that they may have some new evidence. And when I say word, I'm talking about people who are pretty informed and have sources, inside of the inner circles in Tallahassee. So I'm curious to see. I mean, one thing we know for sure is that one of Wendy Adelson's former law school friends, and they're on the outs for whatever reason, that she reached out to the state attorney's office. So I'm curious. Do you think that they go after Wendy?
This is everybody who follows this case. This is their favorite question to ask: is when are they going to arrest Wendy? And I have kind of a similar answer that I would have had to whatever if they would have arrested Donna, and that was years ago. Is that I feel like they would have done it already, but they've waited till Charlie's trial was over to arrest Donna, which was kind of shocking to me. Are they waiting for Donna's trial to be over to arrest Wendy? It seems like that is sort of their pattern. I can't imagine as thorough and as tenacious as these prosecutors are, and what we know about Wendy seems to be enough for their appetite already. And I imagine there's a bunch of stuff we don't know, including what you just alluded to, whatever information they found on Donna's phone. I would be shocked if there's not a bunch of information on that phone. That they wouldn't go after her. And I don't know strategically, I cannot wrap my head around why they would wait. And unless they feel that somehow that will preclude them from having her testify as a witness, because then there's a bunch of Fifth Amendment issues, but you would think she would have those same kind of attendant issues anyways, but maybe they feel that that cuts out the argument that she could make, asking for immunity or declaring the, because you can't just say, I declare the Fifth when you don't really have, when you're not really at jeopardy. So maybe they feel that somehow not charging her prevents her from doing that, and they feel that she might be valuable to call as a witness anyways. I don't know, but I will tell you, I feel like it would be foolish of me to say there's no way they're going to arrest her at this point, because it seems like they're just checking boxes, man. And she's the last one on the list that they haven't ticked off.
Yeah, I think that I personally think they're going to go after her. People don't know this, but Georgia Kappelman, who's kind of the lead, attorney prosecutor on this case, she's been involved the whole time. Her dad played quarterback at FSU, was apparently a great player, and she's got that competitive spirit. Like she has I think a personal animus against Wendy Adelson. I mean, I think that they've just been going methodically like a football game plan. And I personally think that they're that they're going to go after her. It's just going to be a matter of time. And if I was Wendy, man, I would be terrified just looking at my mom and what she's been through and her brother. One thing too, Josh, real quick, is that they do have, this was apparently there was WhatsApp messages between Donna and Wendy and Charlie and all this stuff. And I don't know the state of those, but they did retrieve WhatsApp messages between Donna and a place called Indochina Sun Travel. She's literally in the days after Charlie's conviction, she's furiously messaging this travel agency about visas to Vietnam, checking with them to make sure, hey, this is a non-extradition treaty. And then she WhatsApps them again and says, hey, I need to get a visa expedited. How do I get it expedited? There's like a panic in these WhatsApp messages, and that's going to crush her too.
It is going to crush her, because jurors love this kind of consciousness of guilt stuff. It is something that they just really dig into, because it really demonstrates, it's if they're not going to hear from the defendant, they want to see behavior of the defendant, and this is the behavior of a guilty person to act this way, and jurors really respond to that. But as you're sitting here talking about it, I'm wondering too, like, why did she wait till after his conviction to have this flurry of activity? Book the tickets in advance. Get on that plane to Vietnam while they're deliberating and say, call me in Vietnam and let me know how it all turns out. It just is so funny that it was like they waited till the conviction, and then all of a sudden they thought, I got to flee the country. It's
with a one-way ticket. I mean, it's not like they were it's not like they were at the trial. They didn't go at all. By the way, Harvey, Donna's husband, did show up. He looked horrible.
Yeah, that was interesting today.
Yeah, he's in his early 80s. He looks terrible. Ritter, I got to ask you a question.
Yeah.
Are the Menendez brothers, and I know I'm throwing us down a totally different rabbit hole, and I don't want to disrupt your show, but I got to ask, are they stuck in prison now for life because of DA Nathan Hochman, or you think that they're going to get out?
This case changes directions almost on the daily. So Nathan Hochman gave a press conference last week, and I'll do this really quickly.
Yeah, sorry.
And no, he gave a press conference last week, and after that press conference, I thought, wow, he's not letting him out, because he went into great detail about the violence and the circumstances and the lying and the premeditation and everything regarding the crimes. I just can't imagine the person who would outline it that way. He took like 50 minutes or so to talk about it, outlining it that way, that would then turn a 180 and say, by the way, I want to let him out. I think they've done enough time. So I think he's changed his position from what Gascon was. But if you heard today, Gavin Newsom asked the probation board to give him a recommendation on their threat to society, which is the first kind of step that you take if you're going to grant someone clemency. And those recommendations from the parole board are based upon somebody's conduct while in prison. And from everything we've heard, they've been model inmates. So now you've got Gavin Newsom, who's always had the ability to grant clemency, basically getting the wheels going on clemency, while you've got Nathan Hochman, the DA, basically changing course and saying and all but saying he's going to request that they stay in prison. So I have no idea. I think that Hochman is probably going to be against it, but now I don't know if Gavin Newsom has started down a pathway that ends with him granting them clemency. The whole thing literally so you want to play tennis with you again. The whole thing literally changes day by day. It's insane.
Yeah, it's that's a case that I've obviously been following for many years. I knew about that case when it happened. I've been following it since like '89. It's interesting, and it's sadly it's all coming down to politics, I think. So, and it's not fair because trust me, there's other people in the system who probably deserve another look. They're not going to get it, but his family obviously has been very vocal in wanting them released. So I'm just fascinated by that case.
Yeah, me too. Joel, thank you so much, my friend. This was fantastic. I appreciate you taking the time. I know it's late on the East Coast and that you've absolutely been everywhere on the internet today, but thank you again. And I'll let people see this one more time before I let you go. This is the brand new channel from Surviving the Survivor. Please check it out. STS True Crime Talk. It's at the handle is STS Talk. So thank you again, my friend.
Thank you, Josh. I appreciate it. One very quick thing. In my spare time, I lead a very exciting life. I was in here balancing on a unsteady desk to relight my entire studio, and I saw these hanging shades that I wanted to emulate, and I have a hanging shade right here, but the way it sits there, it looks like a dunce cap. I just realized I'm leaving it exactly the way it is. I'm not touching it. It's total poetic justice. Ritter, you're awesome. And talk to you soon.
Appreciate it, my friend. Take care.
Thanks, guys. Bye-bye.
That was fantastic. He's great. He follows that case closely, as does Jay, who, if he's still in the chat, he was all over that case. There's a lot of great coverage on it too. All right, but as promised, we got to finish up this discussion on Karen Reed, because I didn't want to let you guys or leave you guys hanging, but I did want to have Joel speak about Donna while we had his time, because he was gracious enough to step in here. Originally, he was going to have to be on TV, and we had limited time, but he was able to give us some more. So back to Karen Reed. Boy, if you're not getting whiplash by the amount of gears that we've switched, but back to Karen Reed. So really quickly, in February 2024, ARCA produces their report. Nobody's got a problem saying that there was any inappropriate collusion or communication between the defense and ARCA at that time. March 20th, AJ sends an email to ARCA saying, send us your engagement letter. They respond by saying, we should put a pause on this whole thing. In my view, nothing entirely inappropriate has taken place at that point. Attorneys asking for engagement letters for experts who are going to testify at trial is routine. ARCA seemed to have identified that maybe this might have been abusive of their protective order on the federal side of things. And so they consulted with their folks and they were told, let's put a pause on this whole thing. And from then, March 22nd, until June, it doesn't appear as though there's any other further communication between the defense and ARCA. June 10th, they have this hearing where the judge questions, are you going to actually call witnesses that you've never communicated with? And Yannetti says, we only spoke to ARCA about coordination. Now, Alessi tries to make a big point of this, that at the time that Yannetti is saying that, he is speaking the truth. Here's the thing. Maybe he is. But the fact that he didn't know about the prior communications between Jackson and ARCA, to me, does not get him off for not knowing. In other words, the defense team should be assumed to be aware of what everybody on the defense team is doing. But maybe he didn't know. But then that also begs the question, well, did anybody know that what he was saying to the court was a misstatement? If it was a misstatement, perhaps it wasn't a misstatement. Perhaps all they did talk about was coordinating their testimony and didn't talk about anything in substance at that time. And Allen was only asking for a retainer to make sure that he had them secured for trial. Fine. Again, to me, no super issues arising at this point. Then they do the voir dire. This is to solve the Rule 14 issue. They go through the whole voir dire. Alessi makes a big point of saying they didn't ask these questions. Again, I'm sorry, not the most convincing point in the entire world to me, because Yannetti had just said they didn't talk to them. So for Lally to get up and say, have you communicated? Have you been hired? Have you talked about what you're going to testify to? The fact that he didn't ask that, is that bad on him? Perhaps. But the fact that he didn't ask that is not entirely outrageous, because he's just been told days earlier that they haven't communicated with him. But Alessi makes a great point of saying, listen, if they wanted to find it out, that was their opportunity, and they didn't ask the questions. June 22nd, Arca sends an email to Allen saying, great voir dire. And by the way, there's some issues about nighttime accidents, collisions with pedestrians. And if you don't want me mentioning that, I won't. And this is for the first time where things begin to be problematic, I think, in my view, and more importantly, in the judge's view, because now we're talking about the substance of testimony and what are we going to testify to, and how would you like me to testify, and what is your pleasure, sir, about my testimony. Okay. June 23rd. This is the Sunday before they are going to testify. Arca sends this outline. I'm going to say this. I don't think it registered to Allen at all the significance of receiving that outline. They made a point of saying, of course, Allen was prepared before now. He was prepared likely weeks, months before then for what he was going to be asking. This outline did nothing for him. He either ignored it, saw it, didn't care about it, or the significance of having received it, I don't think registered to him. And maybe I am being too forgiving, but in my view, that is likely what took place. But we don't know unless Allen actually testifies to what he thought of it or even remembers receiving it. But the point here, and I think the point that Alessi tried to make, but that's not really the point, isn't whether or not the questions were used by Allen, whether or not the questions were helpful to Allen, whether or not Allen needed the outline, or whether or not Allen even asked the questions during direct that were in the outline. The point is the relationship. Does Arca perceive there to be a cooperative relationship? Does Arca feel like they are being helpful to the defense by providing them with an outline? They didn't provide an outline to the Commonwealth. They provided it to the defense because I think they viewed themselves as the defense witness. They were being called by the defense. That probably makes sense in their head. Here they're trying to be helpful to the defense by providing an outline for direct examination. The problem is the relationship, because it's not so much did questions get asked during direct that the Commonwealth wasn't aware of. It's the fact that the Commonwealth wasn't allowed to ask because they didn't know. Didn't you, in fact, have this communication with the defense? Didn't you provide them with an outline? You're saying that you're impartial. You're saying that you have no dog in the fight. You're saying that you are this completely objective body, but you did send an outline to the defense, correct? You did encourage the defense to give you feedback, correct? That's the problem. And I think that's the problem that the judge was really focusing on. AJ does his direct. He makes a big, does a lot of questions asking about that there's no prior relationship, that they've never met, that there's no payments exchanged. After trial, we now know there was a July invoice sent for over $23,000. It was for travel expenses and trial prep, and that was paid by the defense. After the defense, very importantly, called the AUSA to say, what do we do about this? They said, go ahead and pay it. The paying of that, to me, is not a problem because they've got the okay from the AUSA, who they should have asked to go to whether or not we should pay this thing. The not disclosing of it this time around is, I think, the problem to the judge. But here's the real question. All of what we've just discussed pertains to the first trial. We're on to trial number 2. Now, what obligations does the defense have, and what problems are created by whatever took place in the first trial? And that's why I'm saying, go back to the audience. The judge spelled it out to you. The judge told us what she was concerned with. Yes, she looked at those prior statements, but I think all of that in the judge's head was just further affirming the suspicions of shenanigans, further affirming that maybe what she's being told hasn't entirely been the truth, further affirming that maybe representations made to her haven't been the most thorough. And then when she hears at a sidebar that we have turned over everything on February 6th, and by February 13th, new emails are for the first time being turned over from the defense to the prosecution. I know that I know that Brennan made a mistake about who gave what, but the fact was that if these things are now being turned over for the first time on February 13th, after representations have been made that everything has been turned over, that I think is the thing that's got her dandruff up more than anything else. So let's get to Calypson's Vixen. Thank you for saving me from shouting. Says, why has nobody just asked for the other timestamps in the email log? Just because it was sent, received at a certain day time, but what are the read receipts timestamps? I think that'll clarify. I think there's a lot of things that need to be done to kind of clarify all of this. I think that other people may need to sign affidavits or give testimony to clarify this whole thing. But to me, the judge just really wants to know, have you made misrepresentations to me? Does the other stuff matter to Cannoni? The prior emails, the prior the paying of the invoice, the prior outline being provided. Yes, only to Cannoni, because this whole thing comes down to a question of credibility in her view. If she feels that all of this is an honest mistake, nothing happens of this. Honestly, if she feels that this was just, hey, a complicated trial that's been going on for months with plenty of emails exchanged and lots of back and forth, and we're dealing with uncharted territory and all of this other stuff and confusion, but this was a God's honest truth mistake, I really feel she goes no harm, no foul. But what about the shenanigans from the Commonwealth? Great point, Donna. Not what the judge is really concerning herself with now, right? Great point, though. If she feels this is an honest mistake, and at best, they were being fast and loose with the facts, that's one thing. Or at worst, they are misrepresenting the relationship with ARCA, then she's left with some options of what she does. And that's really where the rubber hits the road. What is she going to do? Well, I don't know what she's going to do, but I know that she can do one of several things. And I'll tell you which I think she might likely do. One, she could exclude, bottom line prediction, Josh, let's go. Bob's impatient. He's got things to do rather than listen to me. One, she could exclude ARCA, right? She could say, listen, I feel that all of this is a violation of Rule 14 the remedy for these kinds of discovery violations are I'm going to exclude the testimony, and she could kick ARCA out. Will she do that? I don't think so. I think mainly because ARCA was a impartial body hired to begin with, and when they gave their report, nothing has changed from their report, and their report was objective. And so I think to exclude that kind of objective testimony would just be so damaging and so prejudicial that I don't think she'll go down that path. 2, she could revoke AJ's pro hoc vice. A lot of people have talked about this, that Allen's in big hot water, that he might get kicked off of this case. She could say, listen, you are here as an attorney at the pleasure of this court, and I've decided that based upon what these misrepresentations, I view them either as intentional or not intentional. I'm going to revoke your pro hoc vice. That's why Alessi concluded his arguments about, talking about the rules of professional conduct and knowingly false statements and Sixth Amendment rights to choice of counsel and everything else. They're worried about that she might go down that path. Again, I don't think she will because of the fundamental effects that it will have on the defense case. It would be a tremendous blow to the defense to do that this late in the game. I think it would create appealable issues and everything else. So what is she going to do? Well, I don't think she's going to do nothing because I think she thinks this is a problem. And I think she feels she needs a remedy. And I think what she'll probably end up doing is something that will displease everyone. I think she's going to allow Allen to stay on. I think she will allow the defense to call ARCA, but I think she's going to allow the Commonwealth to air all the dirty laundry. I think she's going to allow them to talk about all of the past emails, all of the providing of outlines, all of the asking about your, how would you like me to frame these questions? Whatever it is, whatever there's out there, however they want to argue it, however they want to cross-examine the ARCA witnesses, I think the judge will let them have at it. And I think what made the ARCA witnesses so powerful to the defense in that they did not have a dog in the fight will be dramatically attacked and dramatically cut down. And it could have a fundamental effect on then at that point, the audience will be the jury, and it will have a fundamental effect on how the jury views the ARCA witnesses, as opposed to how they came out kind of looking like these really objective participants the first time around. All right, Kat says, can this affect AJ's future trying cases in Massachusetts, whether he stays on or is kicked off? I can't. I really feel that would be unfair. I will say this. I feel he is one of the most honest attorneys I've ever dealt with, and I feel like I said, he is not willing to risk his bar card for much of anything. And I think it would be a shame if this would tarnish that reputation. But depending on the findings that Judge Cannoni makes, if she makes some pretty devastating findings that she feels that he has made knowingly false statements, or at best was so inconsiderate of the facts to have made those statements, it could have problems. Because again, when you're pro hoc vice, you are not entitled to operate as an attorney. You're operating at the permission of the court, which is a very different thing. Tracy Fagan, thank you so much, says then she will have to admit that they were hired by the feds. Yes, and I think that will come out too, that they were hired by the feds. I think that will come out for sure, because there's no longer a protective order, and they can say that they were hired by the feds and that the feds hired them as an impartial third party, agency to get to the bottom of this. I think that will come out, but I think it will come out too that they may have been hired by the feds, but they were in part paid by the defense. Shy Gal says, no way she will get rid of AJ, in my opinion. That's appellate gold. I agree with you. I just think that too much, these other two options, even the excluding of ARCA and certainly the revoking of AJ's pro hoc vice, are just so nuclear that I just cannot see her doing that. They would be just so, I mean, immediately I could see the defense filing a bevy of writs trying to undo all of that and challenge all of it. And I think she knows that too. I think she knows she's dealing with very skilled, very well-funded, very tenacious defense attorneys who will file any number of things defending on if she does something that drastic. Melinda says, can't they get other experts to say the same thing Arca did? They probably could, but the problem is that Arca already did, and when Arca did it, they did it in a way that was the most clean possible. I mean, this was, you got to think about this. This was like gold handed to the defense. They didn't have to go out and find experts. They didn't have to go out and hire them and have these experts be cross-examined on how much have you been paid? Haven't you been paid by the defense? Didn't they give you X amount of dollars? All of this other stuff. They were hired by somebody third party. And that's never happens for the defense. And then on top of them being hired by somebody third party, uninvolved, it was favorable to the defense. This was gold that fell in their laps, and they were happy to use it. And you could see how they used it, how much they relished telling the jury that. And now I feel like the way this may end up is they won't have as much of an opportunity to highlight all of that for the jurors the second time around. But I think I got through that without anybody threatening to I don't know, throw dog feces at my house. So I feel like that's good. Your blood pressure says, Ms. B says, Josh, relax. Think your blood pressure is going way high. Perhaps you're right. Maybe I need to just calm down and have dinner and go hug the kiddos. Do you think it's about that time, everybody? We've been on here long enough. Thank you so much, everybody, for being here. I do have some parting announcements, though, so I'm not going to let you go just yet because we have some fun stuff coming up this week. First of all, if you missed it on Monday, we have you're killing me. Okay, I'm being told that I have to do the poll. Who won the poll, guys? Rex Heuermann won the poll. All right. We will do Rex Heuermann really quickly. Okay. Rex Heuermann was back in court. And I'm just going to read you. His defense attorney, Michael Brown, made some interesting comments outside of court. You all think Josh is hangry. Maybe he is. Rex Heuermann made some, there's one gentleman who's not hangry, by the way. Probably never been hangry a day in his life. He made some interesting statements outside of court. And I wanted to talk about this because it kind of goes back to something that's been happening with Brian Koberger, another case we've been talking about a lot. Here's his quotes. 1, there is not one shred of biological or forensic evidence that is in his basement, talking about Rex's basement. Not one. Nothing from the victim. Nothing from him. He goes on. So in essence, you're telling me that you have one hair per person, per victim. And he's talking about what was found on the victims. They found like maybe one hair on each victim that they're able to then genetically, through DNA testing and forensics, match back to Heuermann or Heuermann's wife or Heuermann in some sort of way. So you're telling me, in essence, that you have one hair per person per victim. He wasn't conscientious enough or careful enough to make sure that didn't happen. But yet the basement is completely scrubbed. It doesn't make sense. He goes on, my point is, how do you explain that there is nothing in the basement, and that's the kill room? If that's actually transpired and he's the perpetrator, you would have to expect that there would be some remnants in the basement. Okay. Are these good arguments? Sure. It is bizarre, right? There is so much that they can do with forensics and genetics, and they've probably gone over that home more than any home in recent history to search for that type of evidence, and they didn't find anything. So that is remarkable. Is that an argument worth making? Sure it is. Is it an argument he's going to make till he's blue in the face with the jury? Absolutely. I go back to something I learned a very long time ago from a very good medical examiner when I was a DA, and that is the absence of evidence is not evidence of absence. So the fact that you cannot find genetic material in that basement does not mean someone was not killed in that basement. And it's a real, thank you so much, Bob. It is a real 3-card monte. It's a real sleight of hand for the defense attorney to try to make that argument. I commend him. I applaud him. I say, go at it. Have at it. That's absolutely what you should be doing as a defense attorney, is pointing out the things that may seem absurd. Because if they seem absurd, then perhaps that's reasonable doubt. But just because you don't have just because you cannot find evidence of something does not mean that thing didn't happen. And it's hard to wrap your head around that idea of proving a negative sometimes. The absence of evidence, the lack of DNA evidence in that basement is not evidence that nothing occurred in that basement. Farm Girl says he has had how much time to clean that basement? A lot of time. A tremendous amount of time to go through that basement, cleaning it thoroughly. This is also the guy who left himself instructions on how to kill people. This is also the guy who killed all of these people and only left one hair on each of the victims. That's pretty remarkable too. This is obviously someone who was very conscientious of evidence that he was leaving behind. So the fact that nothing was found in that basement is not all that remarkable. Should it be pointed out by the defense? Absolutely. Does it prove that nothing happened? Not even close. The digital evidence is strong in this case. The digital evidence is not only strong, it's some of the most disturbing stuff I think I've ever come across in my career. And that is this manifesto instructions blueprint that it's been referred to that he had about how to kill. And by the way, a lot of that included cleanup. So the fact that we don't have evidence inside that home could mean any number of things, but I don't think that any of those reasonably point towards he's an innocent man. All right. Now am I off the hook? It sounds like I am. Alrighty, Josh, he needs to go to bed. He has to be in court tomorrow. I do. I got to be in court tomorrow in the morning. But we do have some announcements. Okay. One, if you missed it, on Monday, we had our latest in our Courtroom Confidential conversation series that was with Matt Murphy. It was fantastic. I think a lot of you guys saw that. If you haven't seen it, please check it out. Matt's a great guy. He's a former homicide prosecutor. We had a really enjoyable conversation. And he's also the author of The Book of Murder, which is a great, great true crime book where he talks about a lot of the big cases that he prosecuted as a prosecutor. So please check that out. Stay tuned this week, Saturday. We have the weekly roundup, as always, on our New Day Saturday. So please check that out. And then this Sunday is the brand new Sunday Fun Day. And what does that mean? That means that you guys have to go to thecourtroomconfidential.com and you have to go over here and you have to click on send us a voice message. And then you have to start to record us a very nice little question about something you've been wondering. Last time we did this, it was wild and it was a really fun time because we talked in the same episode about ASAP Rocky. And then the next question is about Charlie Manson. And we just had a really enjoyable time going through all those questions and hearing your voices. And I'm hoping we can recreate some of that magic on this coming Sunday. So please go to thecourtroomconfidential.com and leave us a voice message. And then for this Sunday, or pardon me, Monday, Sunday Fun Day puts the fun in the day. Absolutely. Future I appreciate that. Please be there, everybody. It was a blast. That will be this Sunday at 9 a.m. Pacific, noon Eastern. And then finally, this coming Monday, I'm going to announce our brand new conversation. We sat down and interviewed Gavin Fish. He was somebody that you guys recommended very highly. And I will tell you what, I was not disappointed in the least. Really fun conversation. He's a fun guy. We talked about, how he got into being kind of a local reporter and how he's turned that into kind of hunting down cold cases and all the work that he's done, and really, really great conversation. So please stay tuned for that on Monday. In the meantime, thank you to our newest members, Sue May Gill, Crafty Grandma, Crunchy Frog, Analytical Blarney AB, Allie B from Tennessee, Kimberly Rudd, Nancy Kane, Matt Murphy, ever heard of him? He decided to go ahead and join our membership program. Jamie Jane, Cheryl, and Diane L. You guys are all fantastic. We couldn't be doing this without you. If you are curious about how to become a member, well, then you go to thecourtroomconfidential.com and you click on become a member, and you can hear about all the benefits and all the fun stuff that we are trying to provide for you guys over there. Now, you guys have been fantastic this evening. This is fun. I thank you again to Joel. Thank you again to Bob and Jay and Melanie and everybody who was in Court TV, apparently, and everybody who was in the chat tonight. It was such a fun time. Appreciate you all. Have a wonderful evening, everybody, and take care. I will be talking to you soon.